I would really like to begin with gratitude, and I would like to acknowledge the following people. First, I would like to thank our mission partners for tonight's event. We have Leif Cabrazier, and we have Paul Weiss. Would also like to thank the chair of our Thurgood Marshall Selection Committee, Richard Pena. You're good at this. It took our section a couple tries to get this, so you guys are good. I'd also like to recognize the chair of the Thurgood Marshall Dinner Committee, John McDonnell. All right, it's more than a clap, but he does deserve it. I'm so grateful to our CRSJ Leadership Council for all their work this year. Of course, we couldn't have accomplished much without our committee leaders. I consider our committees the backbone of this section. So for our committee leaders, and of course, our section members. Tonight, we celebrate a heroic woman, Sherrilyn Ifill. She really deserves endless applause. She doesn't need the one clap, yeah. And we'll hear opening remarks from another intrepid woman who deserves more than one clap as well, Elaine Jones. Mary Baker Eddy, another woman trailblazer from the 19th century, who founded a church and an international daily newspaper when women didn't even have the right to vote, said, "To speak the truth to every form of error." I feel that CRSJ has done just that this year. That deserves clapping. With 47 free webinars, we have corrected misconceptions by answering over 160 student questions on civil rights laws. We have served truth to youth and the general public while providing a channel for correct answers for educators. We've set up a policy implementation initiative to put ABA policy into practice. We, by the way, have our newest lawyer over here. Can we hold up the newest lawyer? She's so cute. She gets one clap. We launched a 21-day practice on combating Islamophobia. We instituted a Native American land acknowledgement at the start of each of our meetings, which I had the privilege to do on Thursday, and we successfully asked the ABA to do the same. You heard President Reggie Turner do that tonight at the General Assembly. We addressed attacks on critical race theory by sponsoring a 4-part series defining CRT and its importance. We're protecting fair elections by setting up our Lawyers as Changemakers initiative to train lawyers on voter protection, which is so needed with the upcoming elections. We produced 3 Human Rights Magazine issues this year, which you can find out in the lobby. We submitted resolutions to the ABA House of Delegates calling for the right approaches to the issues of the day. And of course, we responded to the various issues raised by Dobbs through multiple late-breaking resolutions, you'll hear Monday and Tuesday, and by taking the lead in setting up a pro bono clearinghouse for lawyers willing to represent those affected by the Dobbs decision. You'll be able to see on the slideshow tonight, when it resumes playing, while you enjoy your dinner, more of our section's accomplishments this year. But for a full list, please view our website, the URL to which you can find at the back of your program. It has been my great honor this year to lead the section of Civil Rights and Social Justice as we accomplished these things this year. So I would like to end as I began this evening with gratitude by thanking you all for attending tonight. Your presence indicates your commitment to truth and justice, and I am proud to stand with you. Tonight I have the honor of introducing to you a woman who almost needs no introduction, but we're going to give her one anyway. She is a woman of firsts. In 1970, she became the first Black woman to graduate from the University of Virginia Law School. She was the first African American to be elected to the ABA Board of Governors in 1988. She was the first woman to hold the position of Director-Counsel and President of the NAACP Legal Defense Fund, the position from which tonight's awardee has just stepped down. She was also one of the first women to defend death row inmates. She has worked on more landmark civil rights cases than I can mention, and she played a key role in passing civil rights legislation such as the Voting Rights Act amendments of 1982, the Fair Housing Act of 1988, the Civil Rights Restoration Act of 1988, and the Civil Rights Act of 1991. Of course, she received the Thurgood Marshall Award herself in 2011. One of the things that stood out to me most, though, about Ms. Jones, Attorney Jones, is that when she started her legal career, she turned down a well-paying job at what was then Richard Nixon's law firm and instead devoted her life to public interest law, where she too spoke the truth to every form of error, and we are better for it. I can't think of anyone better suited to give us remarks appropriate to the occasion tonight and to introduce tonight's awardee. So please help me welcome the incomparable Elaine Jones to the stage.
Hello, everybody. Thank you very, very much for being so gracious and so enthusiastic and so generous. And I know it's you and not the wine, but I'm still very grateful. I want to thank the section. This is an extraordinary place. This is home within the ABA, this section on civil rights and social justice. This is home. When I was active in this section, and I hope it's still the case, that you are the conscience of the ABA. You're the conscious things they really don't want to hear you bring up. You know, you bring it up and you figure out how to get it before the powers that be, and you know, how to phrase whatever it is you're trying to get done, and when to bring it before the House of Delegates, and what kind of support you need to have. And this is where you do the strategy and the thinking and the putting it together, and we're grateful to you. Now, you have always encouraged the association to adopt policies that are supportive of civil rights and social justice. And I remember joining this section in the late 1970s. Yes? That's when it was. In the late 1970s, and it was this section, you know, charity begins at home. This section decided that the Board of Governors had never had an African American to serve on it. That was in the 1970s. So it knew that. Around 10 years later, no African American had served, and the section said, all right, Elaine, we're going to have a vote. And you're going to be our section. Section had the seat coming up. We want you to go to the Board of Governors to represent the section. Now, the section had to do a lot of homework for that to happen. You know, it's a very convoluted process, and it was no accident in all those years you never had anybody. And so, there was leadership that you could turn to, and you did. And you had presidents, and you had John Pickering, and you had a whole bunch of folk. Jack Curtin, and you knew people. You always know people. And you talk to these people, and you look up in 1988, I am on the Board of Governors, representing the section. So that's how I became the first African American on the Board of Governors. It was the section that did it. You didn't know that, because you weren't maybe, some of you were around in the late 70s, 80s. Some of you were not. But the section did that. And it was just not a good look, the way things were looking, And so bring up the photo of the Board of Governors in 1988 and 1989, and I'll bet you'll have a difficult time finding me. I invite you to go in the archives and look that up. Now, 1988, the year I joined the Board of Governors, was the year that tonight's honoree, Sherrilyn Ifill, came to the NAACP Legal Defense Fund. She was 1 year out of NYU Law School, had a little fellowship for a year with the ACLU, and so then decided she wanted to make big money, so she came to LDF. Came to the Legal Defense Fund, and the head of the Legal Defense Fund at that time was the brilliant Julius Chambers. He was the third Director-Counsel. Thurgood was the first, Jack Greenberg next, and then Julius was Director-Counsel from 1984 to December of 1992. And so in 1988, he hired Sherrilyn. Now here was Julius, University of North Carolina graduate, African-American, only African-American in his class, graduated UNO, first in his class, editor of the Law Review. And then they held the graduation dinner at a segregated club, so he couldn't attend. I mean, that was life. That was life. I mean, we moved forward. And so Julius was head of LDF, and his interview with Sherrilyn was very brief. I mean, you don't need to spend a lot of time with Sherrilyn to know you want to hire. I mean, and you could figure that out, which he did. And Sherrilyn came on board, and at that point, I had been in LDF 18 years by that time. So there's a little distance between us, but that's all right, too. We all have something to look forward to. So when she came on board, voting rights was her passion. And that was where a lot of work needed to be done with the Voting Rights Act in terms of implementing it and applying it. And she had two lawyers at the LDF, Lonnie Guinier, and Lonnie was funeralized yesterday at Martha's Vineyard, and Pam Carlin of Stanford. Lonnie and Pam were on the staff, and they left LDF soon after Sherrilyn came on, but they stuck with Sherrilyn those 2 years that she was there, and they advised her. LDF paid them not a dime. They tried to escape into the academy. You know how you guys do. This litigation gets to you after a while, and you got to get a break, so you just got to escape. And so they escaped into the academy, and Sherrilyn relied on them heavily, and do you know that Sherrilyn made a huge difference in voting rights? She was able to get the Voting Rights Act applied to the election of state court judges, the first time it had ever happened. And she did it within 2 years of being at the Legal Defense Fund. Now, Thurgood was one of the greatest civil rights lawyers and strategists of our time. We know that. And so this small band of lawyers that he formed, LDF, in 1940, so it's 82 years today. under the umbrella of this new organizational concept in New York, a non-profit civil rights law firm. The New York courts did not know what he was talking about. A non-profit civil rights law firm. That concept was just, so he had to get the firms to help him and explain, and we became that entity. Now, in that 82 years, LDF has had 7 director-counsels who have completed terms of service. The 8th is Janae Nelson, who's successor to tonight's honoree, and she assumed her duties in March of this year. But tonight we are here to honor Sherrilyn Ifill, LDF's 7th director-counsel, who served ably for nearly 10 years, from 2013 to 2022. Her leadership has been called visionary and transformational during a challenging and transformational time, and every word of that is true. Now, it's when you think about Sherrilyn in that 5 years, she stayed at LDF for 5 years when she got there in '88, and she left in '93. Sherrilyn, I don't take it personally, because I don't think it was personal. But '93 is the year I became director-counsel. And I looked up and you were gone. Now, we have never discussed that. But that's all right. This is among friends. I think it may have been because that beautiful daughter sitting there to your left, and you having beautiful children, and LDF was not easy on family life. LDF is a piece of work when it comes to family. I mean, all that traveling, up and down, you had to make the trips yourself and go to the community meetings and go to and all that, and it couldn't be, delegated to anyone else. So I prefer to think that is why you took your leave. And then you went to the University of Maryland, where you spent 20 years teaching and building your various legal clinics and dealing with the whole question of ex-felons being able to transition back into society, and writing your book on the courthouse lawn on lynching, the study of lynching in the 21st century. And that book, 10 years later, I see that you, Brian Stevenson, we have a new edition. So everybody, you got to read Sherrilyn's book. It's very well done. Okay, that's what do. When you honor people, then you have to go and do what you have to do to honor them. All right, so and it's called On the Courthouse Lawn. Now, as I said earlier, when Julius knew talent and he hired her, Thurgood also knew talent. That's when he saw to it that Julius came to the Legal Defense Fund. Julius was number 3, it connects. Thurgood and Jack Greenberg, Julius Thurgood's successor, raised the money and set up a scholarship fund that they would send young people who wanted to be civil rights lawyers to law school. They would go to law school, they would pay their rent for several years in the office, they would pay for their secretary and give them a salary. And that's how they began to seed lawyers throughout the South who became the Legal Defense Fund cooperating attorneys. And Julius Chambers got that scholarship, he and Marion Wright Edelman, in the early 60s. And that's why Julius had the first interracial law firm in North Carolina. And so all across the country, especially the South, we had that program. Now, that program, Jack carried it from 61 when he became Director-Counsel. He left in 84, but the program was eliminated in 75. Why? It worked. Too much money. Who had that kind of cash? You just couldn't get it. I mean, to send folks to law school, to guarantee them a salary when they came out, to pay the office expenses, the secretary, and the rent. And the fact that he did it for 15 years, we were all very proud of Jack. But when he had to give it up, you didn't hear a whimper from the rest of us because we knew how hard it was. All right, so when Sherrilyn came aboard, her intellect and commitment were readily apparent, and she jumped headfirst into I told you, into the voting rights advocacy, but she also did it as Director-Counsel with all of the issues. As Director-Counsel, she came on in 2013. She taught for 20 years and came back to us in 2013. And one of the things I'm most proud of, and I did after leaving being Director-Counsel, is persuading Sherrilyn to come to the legal defense, or one of many, because we needed her. Sometimes those of you who read the good book, you come into the kingdom for such a time as this. LDF needed Sherrilyn Ifill in 2013. And she came there and gave us everything. On the litigation side, defending fair elections. Remember post office and the joy and all of that? Sherrilyn had to file a lawsuit to try to straighten him out as best she could in terms of delivering the absentee ballots. The think tanks and the task forces that she served on, the Obama task force on police reform, and Biden's task force on the Supreme Court, and the litigation to force reforms in policing, and the accessible transportation issues, fairness and environmental. Remember the water issue in Michigan? That's Sherrilyn trying to straighten out that water issue. Death penalty cases in the Supreme Court. Fair housing, quality public education. The list goes on and on and on. Just go to the website and look at the litigation docket between 2013 and 2022. It's there for, you can see it for yourself. She's a visionary. She succeeded in transforming LDF in ways I could only dream of. I closed the LA office because it didn't have the money. Keep it open. Sherrilyn opened a new Atlanta office because she did have the money and could establish a new one. The board voted to establish a think tank, the Marshall Institute, the Thurgood Marshall Institute. That's that they told me, Elaine, we need a research arm at LDF. That goal was realized when Sherrilyn became Director-Counsel and established the Thurgood Marshall Institute, and it's an interdisciplinary center at LDF, research, advocacy, and archival. You walk down the hall, you're likely to see a lawyer as well as a historian or an economist. That's an integral part of the LDF operation now. On Martin Luther King's birthday last year, 2021, remember that program I told you about that Jack had to shut down at 65? Who gave it a new birth in a new way? As much who strengthened it, Sherrilyn Ifill established at the Legal Defense Fund the Marshall Motley Scholarship Program. That same program that Jack walked away from, Sherrilyn found the resources and started it. Now we have 2 classes of students going to law school who are committed to litigating and practicing civil rights law in the South. That's Sherrilyn. Now, in addition to that, the communications department is unrecognizable in its scope, effect, and size. She's doubled the size of the staff, and she's raised the salaries while she's doubled the size. Not only has she fulfilled her goals, she found the resources. You can have vision and come up with ideas, but you got to find the money to pay for it, and pay for it going out. And she has done much of that. So I'm going to say about Sherrilyn Ifill, she's a practicing trial lawyer. She's a teacher of lawyers and law students. She's a prodigious reader. She's a superb writer. She's an excellent manager. She's an institutional visionary. She's a strategic problem solver, excellent communicator, winning personality, political savvy, all those things I didn't have. She's got all in one package sitting right there. Knows how to speak truth to power, knows how to take advice, also knows how to give it. And she knows how to raise the money. You got to raise the money. Can't do it. And if you don't have the money, I want to see it happen. It does not happen without the resources. That's why I thank all of you here for supporting the work of the section and supporting the work of the American Bar Association. It doesn't happen without the resources. So as I close, I want to say, when Sherrilyn told me she felt it was time to leave, what could I say? 9 years. 9 years. I mean, LDF Director-Counsel is not a job. It's a mission. It's all-consuming. It's day and night. It never stops. It never stops. The problems go on, and they come back. Those you solve come back in different forms. So we got to, all I could say is, Sherrilyn, we are grateful for what you have done. You've got a loving husband and 3 daughters that you haven't seen in 9 years. So who am I to say, you got to stay, round it out, give me another year. I mean, you can't do that. And I said, so I thought about that, and then I thought about what Sherrilyn, I said, you got to let her go. You got to let her have a life. You owe it to her. And 2015, that Amtrak accident, Sherrilyn was on that train at night, going and then playing a train from D.C. and going up to New York somewhere, and the Amtrak had an accident in Philadelphia. 8 people killed. It was a bad one. And as Sherrilyn walking down the track, dazed, not even knowing where she was, this is 2 years into being Director-Counsel. Most folks would have walked in. They would have said enough. She didn't walk. She stayed another 7 years. And that she didn't leave us until the first part of this year. And so she hadn't left us still. All that she knows, all that she's doing now, she's writing her book, which I'm sure she will write somewhat selectively, hopefully. But she's writing her book, and she's thinking, and she's serving on the boards, the Baltimore Museum of Art, Profiles in Courage, she's on boards. She's doing all the wonderful things one does when you continue to give back to the community. So colleagues, friends, section members, you have done something special this evening. You have accomplished a unique achievement. Many people deserve awards, and they do receive them. However, none is more deserving than the honoree you graciously award this evening, Sherrilyn Ifill. I see a broad smile on Thurgood's face, a broad smile. The honoree fits the moment, and the moment embraces the honoree. Thank you all very much.
So it is my distinct honor tonight to bestow upon Sherrilyn Ifill the Thurgood Marshall Award for 2022.
Thank you. Thank you. I'm so grateful to the section, grateful to Beth Wittenberry, who is the current chair, and the newly minted section chair, Juan Thomas. I want to thank Paula Shapiro and the team who got me here. And I want to thank my mentor and idol, Elaine Jones, the one and only, for that wonderful introduction. So this year I received the Thurgood Marshall Lifetime Achievement Award from LDF. Thanks to William Hubbard, I gave the inaugural Justice Ruth Bader Ginsburg keynote at the World Justice Forum at The Hague. Early next year, I'll receive the Brandeis Award from the University of Louisville, and tonight I'm receiving this wonderful award from all of you. And I say that because I really am just a little girl from Queens the youngest of 10 children, who dreamed of doing this work, and it has gone past my wildest imagination of what I hoped when I was a girl and wanted to be a civil rights lawyer it could be. And every moment like this, it goes so fast and you're working so hard, there are very few pause moments. And so I want you to know how much I appreciate this pause moment. My daughter, who's here, Amali, knows that I kind of keep it moving. I don't stop and smell the flowers a lot unless I'm forced to do so. And so I thank you for forcing me to stop and smell the flowers. I'm proud of what we accomplished at LDF over the last 9 years. I had no idea, even though I thought I did, what I was signing up for. 6 months after I became Director-Counsel, the Supreme Court decided the Shelby County case. I think it was the following summer, we all saw Eric Garner say, "I can't breathe," 11 times. That fall, Ferguson exploded. The next year, we saw Walter Scott running in that park in North Charleston, shot by police officers. And then, of course, in 2016, we had the election of Donald Trump. So whatever I thought, and I knew the job was challenging, that's not what I was thinking it was going to be. I wanted to do the job because I believed, like Elaine said, I have no false modesty about it. I believed I was the right person for that time. And it mattered to me that Elaine believed I was the right person, because she does not suffer fools, as you know. And because I know she takes LDF's legacy as seriously as I do, and would not mess around if she didn't think that I was the right person for the position. And so I'm very, very grateful to her. Let me reassure you, Elaine, that you are absolutely correct in why I left LDF in 1993. In fact, you're right. I joined LDF in 1988. I did my first trial when I was 6 months pregnant. I weaned my daughter to do my first Fifth Circuit argument. It was a lot. And I didn't even realize how much it was. By the time my daughter was 3, and it wasn't this daughter, it's the oldest daughter, it was, some days I wouldn't see her, and, I'd work late at the office. And I remember there was one night, I might have been working on the Supreme Court brief in the Houston lawyers case, and I was in the office until about 4 or 5 in the morning. I came home, slept for 2 hours, woke up, tried to get my daughter ready for school, and my husband was going to drive her to her preschool, and she said, "What are you going to do now, Mommy?" And I said, "I think I'm going to, try to get a little bit of sleep." And she said, "You sleep all the time, you're sleeping again?" And I realized she didn't know that, I hadn't come in till 2 hours before. And I thought, she doesn't even know what I do. Like, I'm so out there. But the other reason that I left, Elaine, is the reason many people who leave LDF choose to do so. It's such a rich experience. You learn so much about law, about justice, about race, about inequality, about the voice of your clients. And it's hard to find a place to put what you're learning. You're working, you're litigating, you have cases, and you sense sometimes that you're onto something big, but you don't really have the space to work it out. So I wanted to write. And truthfully, my scholarship for 10 years was all based on the litigation I had done at LDF. It all came out of the lessons of that litigation. And so the timing was just what it was, Elaine. But I still considered LDF my professional home. I worked at LDF for 5 years, and then I taught at University of Maryland Law School for 20 years. And I still regarded LDF as my professional home. That's how deep it gets in your marrow. And so coming back felt like the right thing. So I do want to say on this occasion a few words about the moment in which we find ourselves in this country and what it means actually to be a lawyer committed to civil rights and social justice at this moment. And I want to, of course, talk about and acknowledge the extraordinary person for whom this award is named, Thurgood Marshall. First, I want to say, because I think it's important to say it out loud, that we are in a moment of grave democratic crisis. Not saying it doesn't change the truth. We are in a moment of grave democratic crisis. The trick about this moment, is that whatever happens, we may all meet in this same room next year. Our lives may be okay. We may still have a place to live. We may still have our cars. We may still have a practice. We may have even more of a practice. We'll still eat dinner and drink coffee and wine. But if we don't take this very seriously, we will not be doing all of those things in a democracy. And ultimately, as a profession, we have to decide whether that matters to us. What I learned, to be honest, over the last 5 or 6 years is that there are whole swaths of our profession that appear to be agnostic about whether or not we are a democracy. I'm going to say that again. There are members of our profession, many of them prominently placed, who are agnostic about whether or not we are a democracy. They will tell you they love their country, but whether or not we are a democracy for them is optional. It's probably the only thing that has shocked me over the last 5 or 6 years. So it's important for those of us who believe in democracy to be honest about the nature of the crisis that we are in so that we can understand what we have to do. The reason I think it's important to describe it as a crisis, because when you're in a crisis, you do things differently than you do them in normal times, right? If you're in a crisis in your family, if you have a health crisis, if you have a crisis in the infrastructure of your home, your roof's falling in, when you face a crisis, you behave as though you're in a crisis. And that means that you do things differently than you normally would. And I think this is the challenge at this moment for all of us writ large, but certainly for those of us in this profession, and certainly for those of us in this American Bar Association. Are we behaving as though we are in a democratic crisis? Are we behaving with the kind of urgency that you do when you are in a crisis? Are we expending the capital that has been built up by this organization at this crisis moment? I know it's hard to think about, I take institutions and organizations very, very seriously. I understand what it takes to be the steward of an organization of importance, as I was at LDF. I mean, you know, the first thing was do no harm, right? But as we moved further into 2016 and 2017, I found it necessary to expend some capital, to do some things that maybe you all saw it as being on the edge a little bit for LDF, but I had determined that we were in a crisis. And I also took my marching orders from every Director-Counsel who came before me, beginning with Thurgood. Thurgood was one of one. Justice Marshall was one of one. And his leadership at LDF really inspired me to understand the kind of courage I needed to bring to leading the organization, to expand it beyond what had been its limits. Marshall had no fear of showing up and being present wherever there was the need. That's why Fred Gray knew he could call Justice then Thurgood Marshall after Rosa Parks was arrested and say, I need your help. That's why members of the military who were being court-martialed at alarming rates in Korea had their mothers write to Thurgood Marshall, who tangled with General MacArthur and got permission to go out to Korea and interview these black service members who were being wrongfully court-martialed and intervened on their behalf. It's why Thurgood Marshall went out to the West Coast to deal with the Port Chicago mutiny trials, when black soldiers who saw unsafe conditions, black sailors who saw unsafe conditions refused to work and were accused of mutiny. And he went out to do the investigation and concluded it was not mutiny, it was racism. He understood that in addition to your docket of cases, you have to show up in the moments that are going to define the civil rights questions of the day. And that is how we ended up creating a policing reform project in 2014. We understood that a seismic shift was happening. And that's what I think has to happen in the ABA. I believed that LDF was strong enough, that our reputation was sound enough, that our record was beyond reproach, and that I could step out a little bit at first from the confines of the way I think people traditionally saw the organization, to speak in ways that were more direct, to bring cases that caused some to hesitate. And I want you to know that it was not easy for me either. We worried about everything that we did. It's not easy to sue the President of the United States. In the history of LDF prior to 2016, I think we had sued entities of the federal government twice, maybe? Adams and the Mary Frances Berry Civil Rights Commission, twice. Within 2 years, we had sued, between 2016 and 2018, 7 cabinet members, the President, the Attorney General. It wasn't easy. We didn't know, particularly when it became clear that there was a sense of retaliation that we might be exposing ourselves to. We weren't sure when we would get the audit from hell. It wasn't easy in December of 2020, after we saw what was happening after the election, to sue the President of the United States under the KKK Act, but we did. And we did it because we felt this is what we were made for. We did it because we felt that the mere fact that we were doing it would convey an urgency. And we did it because we were going to bring to it all the signature features of LDF: meticulous research, excellent lawyering, collaboration with law firms and other leaders in the profession. We were going to kick every tire to make sure that our claims were sound, and we were going to conduct ourselves in the way we always do, with respect for the system that we have pledged an oath to, and with a sense of decorum as we do the work. And so we were able to step out and do these things. I still remember the Saturday morning, I woke up and I called our litigation director and said, I think we have to sue the United States Postal Service. Now, I love the United States Postal Service. They had just issued the Gwen Ifill stamp in January, and I was there. It was extraordinary. But when we saw that ballots were not being delivered and that there were issues in 2020 regarding the mail and absentee ballots, we determined that we would have to sue the United States Postal Service, and we did. And we worked getting ballots delivered. Many people don't know this, but LDF still litigation director Sam Spatal was in hearings 9, 10 hours a day into the evening in Judge Emmett Sullivan's court, all throughout those first 2 weeks of November, making sure that ballots got delivered in places where they could still be counted. And then did it again. And then did it again in January for the special election in Georgia. And now we have an ongoing injunction that still covers the United States Postal Service for the next 8 years, so that for elections we can continue to make sure that absentee ballots get prioritized in the mail system. Elaine Jones began LDF's deep engagement around the issue of judicial appointments. And I have tried to borrow from each Director-Counsel. And from Elaine, I borrowed the deep engagement in Washington, D.C., with both legislation and with the appointment of judicial nominees. And I know that the ABA plays obviously a powerful role in that as well. And we continued to play that role, and that wasn't easy for us either. We litigate in all of these courts. We litigate in the United States Supreme Court. It's not easy to be on prime time, you know, talking about a nominee. But when you all don't speak out, let me back up and say this first, and then come back around to the hard part of it. One of the things that was so remarkable about Thurgood Marshall is that he was a trial lawyer. I mean, I'll say that again. He was a trial lawyer. And I've always kept that in my head. It matters to me. He genuinely believed in the rule of law and the power of law to address injustice and discrimination, and I am the same. I'm a true believer. Still, I'm also a true believer in litigation. I taught civil procedure for 20 years because I love it. I loved civil procedure in law school. That's how weird I am. Because I believe that litigation has a power for the people that I represent. It allows them to speak. If you can get yourself to trial in a courtroom in which everyone has to stay still and listen to them. And what I experienced at LDF, my first tour of duty, the first time I felt that, the ordinary people that I represented who drove all the way out to Waco, Texas, to come to court, who lamented their inability to participate and elect candidates that they wanted to serve on the judiciary. And when they got on the stand, they spoke, and sometimes for the first time, all of these powerful people from the AG's office, from their county, from the courts, were silent and had to listen to them. They brought these stories, their narratives, their truth, into court. And it was our job as skilled litigators to help the court listen to that testimony, receive the evidence that we developed, listen to the experts, Wendy Green, who's here and was an expert witness for us just a couple years ago and still is in a case challenging natural hair discrimination. So often we're taking something that a judge has never heard of before, that they know nothing about, And our clients get to tell their story, and we bring them people that they never heard of. They didn't know there was an expert on natural hair. And with our skillful lawyering, those stories go through the crucible of litigation, and when they come out the other end, if we are successful, they are truth. They're findings of fact. A judge has determined that what she said isn't just what she said, it is the truth. And the people we represent have been fighting for that, for their truth to be recognized. So I've believed in litigation, that if they can get heard, I've said it all the time, if we get to trial, I like our chances. Doesn't matter who the judge is. We win before conservative trial court judges all the time. But you know what does matter? Is having a judge that knows something about litigation. So back again to the process of judicial nominees. It's not just ideology. I'm not suggesting that's not important. It is important. But when you don't speak out about a judge who's never litigated a case, has no experience, and my attorneys have to go before my erstwhile attorneys, I keep forgetting I'm no longer in that position, but LDF's attorneys and others from other civil rights organizations, and maybe some of you, have to appear before these judges who don't know what they're doing. It interrupts the ability of our clients to be heard, to be heard. Now, why is this important? We win cases, we also lose cases, as you know. What has always amazed me since my first, okay, I won my first case, so I can't say my first case. The first case I lost is that my clients always had a different lens. I mean, I'm so competitive, I must win. And when I don't, I'm just beside myself. And my clients would always say, no, I'll never forget the day that Ms. Jones was on the stand and everybody had to listen to her. I'll never forget the look on the face when you cross-examined this person. They pulled out of it different things than I was thinking about. The process for them, so long as they felt heard, mattered. So when we talk about respect for the courts and respect for the legitimacy of the courts and judges and the system, it is that ability to be heard. Now let me tell you why that's extra important in this moment. Because increasingly, we are not part of the ongoing debates and conversations about things that are happening in our profession that are not directly about civil rights and social justice. Take, for example, the shadow docket on the Supreme Court, the emergency docket, if you will. One of the reasons I was willing to join the President Biden's commission on the Supreme Court was because I wanted to bring the perspective, first of all, of a real litigator and of our clients into these conversations. And far too often we absent ourselves from the rooms where those kinds of conversations are happening. But when you litigate a case for 2 weeks during a pandemic, in order to allow black voters and disabled voters in Alabama to vote absentee, and you win that case, and you get a 192-page opinion from the trial court judge enjoining Alabama and compelling them to allow more relaxed absentee voting procedures to happen so that black and disabled voters will not have to do all the things that Alabama then required you to do to absentee vote, which is have your vote, your ballot notarized and to have your photo attached to the ballot and so on and so forth. And the Secretary of State said, well, you know, they should just go to a Kinko's. This is at the height of COVID, when it was ravaging our communities. And find a notary or 2 witnesses when we were all telling our parents and grandparents, don't let anybody in. So we win that case, 192-page opinion, And the judge quotes liberally from the testimony of our witnesses who said, my parents and my grandparents had to risk their lives to vote. We shouldn't have to do that today. And that case then disappears because after it's upheld in the 11th Circuit, the state likes its chances with the Supreme Court and puts it on the emergency docket. And the court stays the judgment of the district court. And then you have to tell your client that not only does that mean that things are back the way they were because we could never litigate in time for the election that's just coming in 2 months. We could never get it all the way back up through the system. But also it means that that 192-page opinion, poof, it's disappeared. These are harder things to explain to your clients and have them still believe in the justice system. So when you hear conversations about the shadow docket, it's not some arcane thing for Supreme Court litigators. It's about a process increasingly used in ways that affect the rights of millions of ordinary people, prisoners at risk of COVID, voters. We know that this is true. Women in Texas, that period until Dobbs was ultimately decided should have been one of the most horrifying and frightening periods for our profession, when the Supreme Court allowed a state to go forward with a plan that would allow essentially bounty hunters to be created to interfere with what the court had said was a fundamental right in 1973. Roe had not been overturned, and yet the court allowed Texas to continue. Our voices were needed then. Your voice was needed then, robustly, to talk about that process, not just the outcome you wanted, but that the process undermined the integrity of the legal system. This is the moment for expending the capital. I was saying to Beth at the table, we will either speak now publicly with our voices and be heard, or our country will be so transformed that we will only be able to whisper in our homes about these things. And if you believe it can't happen here, think about all of the elements. Voter suppression. The willingness now not only to just suppress votes, but to overturn elections. Intimidation of election officials, that it's happening unabated. We still don't have legislation that would protect election workers from threats. Police violence. Maybe it's gone out of everyone's head since millions of people took to the street after George Floyd was killed. But if we saw what we see here in this country, in videos that at least I see every day, in any other country, with armed officers of the state killing innocent and unarmed people with impunity, we would know what it was. We would know what it was. Hypersegregation. The takeover of history and memory by states that have decided that the truth does not serve their purposes. These are all the hallmarks of rising fascism and authoritarianism. And lying to ourselves will not make it go away. So my charge is for you to step out. Do what Thurgood did. Go to Korea, tangle with General MacArthur if you have to do what we had the courage to do. It's not easy. The personal threats are real. We've all had to change our lives in ways you can't imagine. I don't talk about it publicly because it's nothing to compare to the danger that Thurgood faced in his day. It's just part of what we have to deal with. But just know that. Know that when we are all appropriately concerned when we fear that judges may face violence, as Judge Salas did several years ago in New Jersey, just know that those of us who do this work have also been living with the reality of threats and have had to accommodate our lives in order to speak. And so I feel quite comfortable requiring you to do so as well. I'm grateful to you tonight for this award. I'm incredibly proud to be part of the team of civil rights lawyers who I think do the noblest work in this country as lawyers. I love being part of this profession, but it's our profession. And if we don't protect it, if we don't use it for the purposes of justice and equality, if we don't make our voices heard on Capitol Hill, in state bars, in our own communities, in the places where they're debating issues like stare decisis, we will have disserved ourselves in this profession. It's no accident that the dissenting justices in Dobbs quoted from the final dissent of Thurgood Marshall in Payne versus Tennessee, in which Marshall lamented the court's decision to step away from and abandon stare decisis in a case involving criminal law. And Marshall opened his dissent with the line, "Power, not reason, is the currency of this new court's decision-making." Power, he said, not reason, is the currency of this new court's decision-making. And that is the line that Justices Breyer and Kagan and Sotomayor quoted to describe the majority opinion in Dobbs. We're in a crisis moment, and I hope that you all will feel inspired, encouraged, and convicted to behave as though we are in a crisis moment, and that you will use your voice in this important organization to ensure that we uphold the oaths that every one of us took when we became lawyers. Democracies unravel when the rule of law unravels. There is no place that is a democracy that doesn't uphold the rule of law. So we're an essential part of the future of this country. I take it very seriously. I will be writing about it and thinking about the next ways that I want to do this work. I'm not stepping away from the fight, even though I'm stepping away from LDF, and I know you are not either. Thank you so much for this honor.
What a wonderful call to action. Give our honoree another hand, please. Since I am the only person keeping you from a late night cocktail or the after party, let me be very brief. I've been asked to thank our sponsors. If you turn to page 7, you will see a list of our sponsors. I want to thank all of our sponsors for your contribution and your support to this dinner. We could not do this without you. We are so grateful for your contribution and the donations you made. I also want to encourage all of you to please think about giving and supporting FJE. We need your support as we continue to do the work of our section and the work of our profession. It is important that we have the money to do the mission. I heard that earlier today in another meeting, but we need the resources to carry out the work of our section and our profession. So please consider giving to FJE. I also want to thank the members of our leadership team, our section council. I thank you so much for serving this year. The selection committee who selected our honoree tonight, we're so grateful for your service as well. I also want to ask all of our past chairs of our section to please stand. We stand on your shoulders. All past section chairs, please stand. I also want to ask all past presidents of the American Bar Association to please stand. We thank you for your service. I know we have a few here tonight. We thank you. We stand on your shoulders. I also want to thank our incredible staff of our section. We could not do this without Paula, Allie, Rashika. We thank you for all that you do. We've heard some inspiring words tonight. We should all be fortified and renewed to continue the work of Thurgood Marshall, of Elaine Jones, and Sherrilyn Ifill. I want to leave you simply with this thought. For those of you who attended the medal ceremony this afternoon, where we honored retired Justice Stephen Breyer, you heard the Soul Children of Chicago. They sang, yes, they sang a powerful rendition of America the Beautiful. And as I listened to them sing that song, and those words that were written so beautifully by Catherine Lee Bates, I was reminded of the third stanza of that song that simply says, "Oh, beautiful, for patriots' dreams that sees beyond the years, that alabaster cities gleam undimmed by human tears. America, America, God mend her every flaw and confirm thy soul with self-control, thy liberty in law." My favorite line there is simply this: to mend thine every flaw. That is the work of our section. That is the work we've been reminded of tonight. Let us leave here tonight committed to mending thine every flaw. Good night.